Order, good morning. Welcome to this Planning, Taxi, Licensing and Rights of Way Committee meeting. My name is Councillor Carl Lewis and I have the pleasure today of chairing this meeting. First of all, I'd like to apologise for the slight delay in starting. We have some technical issues within the chamber today, but we will persevere. Moving on to the first item on the agenda, which is number 1, which is apologies. Over to you, Carol, for the roll call, please.
Thank you, Chair. So, Councillor Carl Lewis.
Present.
Councillor Gareth D. Jones.
Amen.
Councillor Tom Colbert has sent apologies. Councillor Angela Davis.
Amma.
Councillor Deb Edwards. Councillor Deb Edwards.
Yeah, I'm present.
Yep, lovely, thank you. Councillor Les George has sent apologies. Councillor Halwyn Hume.
Present.
Councillor Peter James.
Present.
Councillor Adrian Jones.
Present.
Councillor Gareth E. Jones.
Present.
Councillor Karina Kenyon Wade. Councillor Ian McIntosh.
Present.
Councillor Jeff Morgan.
Present.
Councillor Gareth Pugh.
Present.
Councillor Edwin Roderick. Councillor Gwynfor Thomas.
Present.
Councillor Elwyn Vaughan.
Amma.
Councillor Jonathan Wilkinson.
Apologies, Carol, sorry.
Apologies from Councillor Jonathan Wilkinson, thank you. And Councillor Hugh Williams.
Amen.
Thank you.
Okay, thank you, Carol, for that roll call. Just a reminder to members, after this meeting, we will be having a informal briefing with Peter Morris and Gwyn Davis regarding the Audit Wales report. So please do hang on, that will be offline purely for this committee. We'll move on now to item number 2, minutes from the previous meeting, which took place on the 6th of April 2023. There are pages 5, 6, 7 and 8. Do I have a proposer and seconder to recommend they were an accurate representation of what transpired, please? Thank you very much, Vice Chair. Thank you very much, Deb Edwards. Moving on now to item number 3, which is declaration of interest. A, to receive any declarations of interest from members relating to items to be considered on the agenda. No, okay. B, to receive members' requests that a record be made of their membership of town or community councils where discussion has taken place on matters for the consideration of this committee. Okay. C, to receive declarations from members of the committee that they'll be acting as a local representative in respect to the individual application being considered by the committee. Excuse me. D, to note details of members of the county council who are not members of the committee who will be acting as a local representative in respect to an individual application being considered by the committee. Yeah, okay. On to the first application, the only application we have today. Has everyone had a chance to read the updates which came in yesterday? If anyone hasn't had a chance, please raise your hand. Okay, we can proceed. Like I say, this is the only planning application we have today, which is 21/2343/FUL formulation of hardcore over storage area retrospective, together with erection of a 2.4 meter high security perimeter fence with gates and construction of 9 bollard lights at a maximum height of 800 mil and improvements to existing access. This is at the Vine, Ardleen, Llanymynech. Taking us through this report is Cerys Denham. Over to you.
I just need to bring in the speaker.
Okay, yes, certainly. We'll pause momentarily.
So I've got Carol Davis, who's the clerk of the Community Council. So I'll bring you in, Carol.
Hello, Carol. We're just waiting for our speaker to come in.
I've got Carol in. You just need to unmute your microphone, Carol.
That's better. That's better.
Hello.
Sorry about that. Good morning, everyone. Thank you for listening to us today. The fundamental principle here is that the development has changed greatly from that which was granted in the outline consent in 2020. The original.
Excuse me, Carol.
Yeah.
Not just yet.
Oh, right. Sorry.
Okay, it's okay. I'm going to introduce the application, and then I'll, once the officers outlined the application, I'll come to you and you'll have your 5 minutes.
Okay, thank you.
Okay, sorry about that. Okay, taking us through this application is Karis Denham. Over to you, Karis.
Good morning, councillors. I say the application before you is 212343 full as described, the formation of hardcore storage area with the erection of a 2.4 metre high security perimeter fence and gates, and the construction of 8 number bollard lights to a maximum height of 800 millimetres and improvements to the existing access.
Go several pages now. Having a bit of difficulty moving the presentation on the screen, so just bear with us, please. We got those IT chaps again, Carol. They're available. Do apologise about this, members and members of the public. Seem to be having issues with IT today. Yeah, we'll do. You haven't got it. I think it's just frozen completely. Yeah, anyway, I'm going to deal with it. Is to leave. Yeah, if you do it that way, then. The client leaves the meeting as well to make sure. Do apologise, members. We're going to break for 2 minutes just to sort out the technical issues we have here. Okay, members of the public, welcome back. We've had some technical issues in the chamber this morning. I can only apologise for that. We'll now take an additional roll call. So over to you, please, Carol, for that roll call.
Right, thank you, Chair. So, Councillor Carl Lewis.
Present.
Councillor Gareth D. Jones. Councillor Tom Colbert was apologies. Councillor Angela Davis. Councillor Deb Edwards.
Present.
Councillor Les George was apologies. Councillor Harlan Hume.
Present.
Councillor Peter James. Councillor Adrian Jones. Councillor Gareth E. Jones.
Present.
Councillor Karina Kenyon Wade. Councillor Ian McIntosh.
Present.
Councillor Jeff Morgan.
Present.
Councillor Gareth Pugh.
Present.
Councillor Edwin Roderick. Councillor Gwynfor Thomas.
Yes, present.
Councillor Elwyn Vaughan. Councillor Jonathan Wilkinson was apologies, and then Councillor Hugh Williams.
Okay, thank you for that, Carol. The application is 21/2343/FUL. Formulation of hardcore storage area retrospective together with erection of a 2.4 meter high security perimeter fence with gates and the construction of 8 bollards lights at a maximum height of 800 mil and improvements to the existing access of the Vine, Ardleen, Llanymynech. Taking us through this application is Caris Denham. Over to you, Caris, please.
Right. Good morning, councillors. So the application before you is 21/2343 FUL, as describing the formation of hardcore over storage areas, which is a retrospective part of the application, together with the erection of the 2.4 meter high security fence with 2 gates and the construction of 8 number bollard lighting to a maximum height of 800 millimeters and improvements to the existing access at the Vine, Ardleen. Right. The application site is located in the community of Llandriniaeth and Ardleen and is within an area of open countryside as designated under the Paris Local Development Plan 2018. The site is approximately 380 metres southwest of the village development boundary and is indicated by the red circle around the site on the map. Next slide. This aerial photograph just shows the context of the site within the surrounding area and the open countryside nature of the site. The site itself extends to approximately 0.5 hectares and as seen from this aerial image is surrounded by agricultural land. There's an established touring caravan site to the southwest of the application site. There's also residential development to the southeast and a residential property to the northern boundary. As seen on the location plan, the site, as outlined red, is located to the north of the property known as the Vine and is to the north of the County Highway B4392. The site is accessed by an established private driveway and there are a number of public rights of way through or near the application site as dashed green on the location plan. Next. This block plan shows the site in a closer scale. The site has boundary hedges to all sides and the proposed perimeter fence is as indicated by the dashed line on the block plan. The proposed bollard lighting is indicated by the small dots on the eastern boundary of the site. And I'd now like just to hand over to the speaker.
Thank you, Caris. We'll go now to Carol Davis, who is the clerk of Llandriniaeth and Ardleen Community Council. Thank you, Carol, for being so patient there. Yeah, you have 5 minutes and you may begin when you're ready.
Thank you very much and good morning. The fundamental principle here is that the development has changed greatly from that which was granted in the outline consent in 2020. The original concept was for caravan storage in a grassy field. The design and access statement submitted at that time clearly stated that the land would remain as improved grassland. And you can see from the planning officer's report that the surrounding area is all improved grassland. What you see today is an urban car park for caravans and totally out of character in this peaceful rural setting, only 150 metres from the Montgomery Canal. Residents have spoken of the topsoil being removed off the site and replaced with several hundred tonnes of hardcore. Residents have also seen following that the surface water runoff is faster now and filters down the driveway and pools onto the B4392, which is the Ardlene to Gilsfield Road. During prolonged wet spells, this has also led to flooding of 2 properties on the opposite side of the road. The sustainable drainage team are supposed to complement and work with the planning department, and we would urge that planning permission is refused or deferred today until a full analysis is carried out by the SUDS team, so that the full effect of this change of the surface to hardcore is fully evaluated. No one should experience increased flooding due to this development, and the increased runoff should be calculated and brought back to this committee for fuller consideration. Thank you for your time.
Thank you very much, Carol Davis. That concludes our speakers. I'll hand back now to Karis to take us to her recommendation. Thank you, Karis, please.
Next slide. Thank you. I think just by background to the planning application, planning consent 20/0495/full was granted for the use of the site as a touring caravan storage site. This application just seeks to amend the site by providing a hardcore surface, with being retrospective, and the provision of the security fencing and gates as shown on the slide, and an additional bollard lighting. Thank you. During the determination of the planning application, amended plans were submitted to replace the proposed column lighting with 8-number bollard lighting to a maximum height of 800 millimetres as shown on the slide. The updated committee report sent to you includes comments from the Environmental Protection team, who raised no objection to the proposed lighting scheme. This slide just shows the site access from the B4392 highway coming from the southwest direction into the village. The following photograph slide just shows the site being approached from the village and from the northeast. The site is accessed from established access with proposed improvements. Some improvements have already been made under the previous application 20/0495 full. The local highways authority have been consulted and raised no objection, subject to a number of conditions being attached to any granted consent, which have been outlined within the report. It is noted within the committee report there has been a number of concerns raised by the public representation and community council in respect to highways access. But as previously noted, planning consent 20/0495 full was approved for touring caravan storage on the application site. And given the local highways authority raised no objection, it is considered the proposal will not have any adverse impact on highway safety. I think the slide just shows the access going into the site from the caravan storage site from the existing access site. This picture is taken from the southern entrance of the caravan storage site. It can be noted that the storage site is fully enclosed by established boundary hedging, which the agent acting on behalf of the applicant has confirmed will be retained. So it can be conditioned so that the height of the established hedging is maintained above the proposed height of the security fencing. Next slide. This picture is just taken from the northern boundary of the site, looking south towards the vine and the village, and just shows the context of the site. Next. I think this slide just shows, again, from the southern aspect of the site, just looking along the western boundary of the site. I think as seen on the locating plan, there are a number of public rights of way routed along around the site. There's one routed along this boundary. The council's right of way team have been consulted and raised no objections, subject to a number of conditions being attached to any consent. A 3-metre wide corridor would be left between the storage site and the hedge to exclude the right of way from the caravan storage site. And again, the condition has been recommended to be attached to any grant of consent, and advisory note attached to any planning consent. I think It is acknowledged that there have been concerns raised in respect to flooding. It is noted that the storage site is hardcore, therefore it is a permeable surface. It's not impermeable. And also the caravan storage site is located outside of any designated surface water or small watercourses flood zone. Only a small area of the existing access onto the highway is within the flood zones as identified on the flood map. And also the site would be subject to SAB approval under separate under that SAB approval regime. I think all other issues have been addressed within the committee report and the updated report. The recommendation is therefore one of approval, subject to the conditions outlined within the main committee report. Thank you.
Thank you, Karis. Over to members for discussion, please. Who would like to start us off? Councillor Edwin Roderick, please.
Yeah, sorry, I missed a little bit on the part that you were discussing about the flooding part of it on the end. Can you just repeat that, please?
I said that the site area is of hardcore surface, so it is a permeable surface. The whole of the storage site is outside of any identified surface water or small watercourses flood zones. There's a small section of the access onto the highway which is within that identified flood zone, and the site itself would be subject to SAB approval if consent was given, which would control the surface disposal of surface water on that site.
Thank you. Yeah.
Thank you very much. Councillor Adrian Jones, please.
Thank you, Chair. Can I just ask, well, discuss a bit more about the security fence? It has been mentioned in the report that the original look of the fence is going to be industrial, and it certainly does. Why does it need to be so high? And you know, it is intrusive, yeah.
I think that the proposal from the applicant was a 2.4 metre high fence for security purposes. There is a recommended condition that would be painted forest green to assimilate within the landscape. The previous planning consent, the 200495 full, is subject to a condition which states that boundary hedge should be maintained to a height of 3 metres, which would be in excess of the height of the proposed fencing, and therefore this fencing would be screened from all angles by that boundary hedge, and that can be enforced by that planning condition.
Okay, thank you.
Thank you very much, Councillor Adrian Jones. Councillor Gareth E. Jones, please.
Thank you, Chair. Just a couple of questions. I note in the presentation by the clerk, one of the concerns was pooling of water on the highway and potential flooding on properties opposite. Condition 13 states no surface water drainage from the site shall be allowed to discharge on the county highway. How will that be enforced?
Let's say it is a condition which can be enforced against that. That's a recommendation from highways, and also that the SAB approval would monitor this, would regulate the surface water disposal from the site, so it wouldn't be able to enter the highway.
Thank you. Could I ask one follow on?
Yes,
not linked to that. I think that's fine, and I assume that the community council could raise the issues about enforcement with the planning team. Second one, I note there's a 3 metre wide gap along the bridleway. Personally, I've got concerns whether that's wide enough. You know, if you've got 2 horses travelling either way, personally, I think they need more than 3 metres to pass. And also, if I was walking the bridleway, I'm always nervous of horses. I like to give them a good breadth of easement. I'm just wondering, is there an option to make it actually wider than 3 metres?
The 3 metre width is the width which is recommended from the rights of way team. It has, throughout the course of the application, it has been widened to that 3 metres, which was stipulated by the rights of way team. It's quite a straight access route, so you could see from either end if anything was coming in the other direction. So I think that was just deemed to be a wide enough
Thank you.
access path.
Okay, thank you very much, councillor Gareth E. Jones. Councillor Howard Hugh, please.
Yes, thank you, Chair. But two questions. Is there a sub requirement on this application?
Yes, the application would be subject to a SAB approval for the disposal of surface water. Yes, yeah.
But had they done this correctly the first time round, would the sub have been necessary then?
I understand all developments over 100 square meters would be live, but would need a SAB approval. So the hardcore has only come under this application, so it wouldn't have been required. I think.
Okay. Okay, so that's resulted in them incurring additional costs because of non-compliance of conditions, basically. The second question is, this is a retrospective planning application. How will this authority ensure that the applicant will now adhere to the conditions that are going to be applied to this?
I say the application is subject to those conditions, and if there is a breach of condition, an enforcement complaint could be raised, and then it could be dealt with through that enforcement process.
Okay, thank you very much.
Thank you very much, councillor Howard Hugh. Members, I'm in your hands. We haven't got a decision to go either way on this application. Councillor Elwyn Vaughan, please.
Diolch Cadeirydd. Well, having heard the questions there and responses, I think we're in a clear position and I move the recommendation. Diolch yn fawr.
Diolch yn fawr, councillor Elwyn. Councillor Gareth Pugh, please.
Thank you, Chair. Could you just take me back to the photograph of where the original axis joins the highway, please? Have you got a closer one of it? There we go. So there we've got tarmac, haven't we? I don't know how far, but it looks a long way before the hardcore permeable surface would join that tarmac. I'd question the stone surface that we've got in question today. I wouldn't have thought comes anywhere near the tarmac for that drive. And if there is pooling on that road, it would be subject to what was done a long time ago with the original axis. So what we're looking at today, I wouldn't have thought causes any more of a problem than what's already there. So when you're ready, Chair, I'll go with Elwyn and second it. Thank you.
Thank you very much, councillor Gareth Pugh. Okay, any other members want to come forward with comments? If not, I'll take it to the vote. Nope. Okay, members, it has been proposed and duly seconded to go along with the officer's recommendation as set out in the update report. Those members wishing to go along with that officer's recommendation, please indicate in the voting slip, which will appear momentarily. Thank you. Right, should we take a verbal? If it's difficult, Carol, I'll take a verbal. Members, we're having a bit of difficulty with the voting slips. We may have to take a verbal vote off each member. Okay, it's a verbal, members, so we'll start now. Carol will go through everyone.
Apologies, members, I can't open the app. Councillor Carl Lewis,
4.
Councillor Gareth D Jones, Councillor Angela Davis,
Councillor
Councillor
Angela,
Angela,
come back.
Sorry, Chair. I just had a cough fit. I had to go and get some water. 4, sorry.
Councillor Deb Edwards,
Or
Councillor Halwyn Hume,
4.
Councillor Peter James,
4.
Councillor Adrian Jones,
4.
Councillor Gareth E Jones,
4.
Councillor Karina Kenyon Wade, Councillor Ian McIntosh,
4.
Councillor Jeff Morgan,
4.
Councillor Gareth Pugh,
4.
Councillor Edwin Roderick,
4.
Councillor Gwynfor Thomas,
4.
Councillor Elwyn Vaughan,
4.
Councillor Hugh Williams.
4.
Thank you, Chair. That's everybody. So everybody's in favour of the application.
Thank you very much, Carol. That is unanimous, as you correctly point out. And that concludes the planning applications for today. So thank you, Karis. Moving on now to the rights of way application we've got here. Just bear with me, members. Well, it's a correction on the Common Lands Register. Okay, no problem. Yes, we can. Councillor Jeff Morgan, has to leave, Carol, so just to let you know. Okay, we'll begin. This is item number 7 on the agenda, members, which is the rights of way application we've got in front of us, which is application 17-001CA to correct a register on common land. Taking us through this application is Sian Barnes. Over to you, Sian.
Thank you, Chair. So as the Chair has mentioned, this is a corrective application, which we don't receive particularly frequently, but which my colleague has brought to committee on a couple of occasions, a couple of different examples. This example is a little different in that it is about, and it's an application to remove land from the Register of Common Land, and it is probably the largest tract that we've dealt with so far. So it has had some complexities. So corrections of the Register of Common Land, we have a legal duty to determine those applications. There are a small number of types of corrective application that go external to the council, to PEDU, Planning Inspectorate as was. This particular type of application to remove land from the register wrongly registered is a legal duty of the council to determine when the application is decided to be validly made, which this one is. So the effect of this application, if it is accepted as made, is the removal of 19.27 hectares of wrongly registered land from Register Unit MCL 76, which is in the north of the county in Montgomeryshire. So the prefix M denotes Montgomeryshire and 76 is the unique reference given to that Commons Register unit. More specifically though, the application relates to Area Y. As you'll see in a moment, the common MCL 76 is divided in its registration into a number of different areas, A through to Y, and this application only affects Area Y, and that is significant in terms of the evidence that we've looked at. The remainder of the common is not affected by the application. So members will see in your pack, you have a location plan to give you a sort of a zoomed out view. In terms of location, you have on the top left-hand side of the screen, further over would be Machynlleth. On the top right-hand side of the screen, again, not off the picture at the moment, would be Llanbrynmawr to give you some geographical orientation. The land affected is the area indicated by a little red arrow. The orange colour on the mapping, if you're not familiar with it, denotes open access land under the Countryside and Rights of Way Act, much of which empowers is common land, but not all of it. Some of it may also be forestry, and some of it may in fact be mountain, moor, hill or down that is not common land. In this case, it is. Zooming in a bit, the area affected by the application, Area Y, is coloured, is ring bound in, has a boundary of red, as you can see there. The purple dashes denote other land that's adjoining it that is common land, but is not affected by the application. So it is just this piece, Area Y, with the red boundary that is affected. In terms of the legal criteria, this application is made under the Commons Act of 2006. Under section 22 and schedule 2, specifically paragraph 7. So back in 2017, the Welsh Government introduced new regulations and brought into effect the provisions of the Commons Act in Wales, which allowed for the register to be corrected, really for the first time since the registers came into being in the late 1960s and early 1970s. This particular application, the legal criteria for removal of wrongly registered common land, i.e. the applicant is saying that it shouldn't have been put in there in the first place, we need to be able to demonstrate first that the land was provisionally registered as common land under section 4 of the 1965 Act, i.e. it went onto the register in the first place, that the provisional registration of the land as common land was not referred to a Commons Commissioner under section 5 of the 65 Act, which is the Commons Registration Act of 1965, under which the original registers came into being, that registration became final, and that also importantly, immediately before it was provisionally registered, before it went on there, the land was not any of the following: that it was not land subject to rights of common, that it was not wasteland of a manor, that it was not a town or village green within the meaning of the 1965 Act, as originally enacted, and it was not land of a description specified in section 11 of the Enclosure Act of 1845. We will go through each of these areas individually, but basically it is for the applicant to prove their case. So for these applications, the research burden does not lie with the County Council and officers. It is for the applicant and any objectors to put forward their evidence and for the county council to consider what is presented. We don't have a duty to go away and find additional information, except within very, very confined limits. So the first test was this land registered, provisionally registered as common land. What you see in front of you, and again you have in your pack, is an extract from our current Register of Common Land. And in fact, these are not updated in quite the way that you might expect. They are as they appeared in the 1967 to 70s, but with any subsequent amendments noted on there. So what you'll notice on the right-hand part of the picture, because it does sit across two sheets, you've got Area Y. You have in fact got around that some land that has black hatching on it. That is land that was provisionally registered as common land. It was put forward, but then it was actually subsequently removed from the register, which is important, and we will discuss that in a moment. So the boundary of the common land is shown in green. It's a statutory colouring, and there are ownership or grazier boundaries. So as you can see, it's heavily subdivided. Not all commons are heavily subdivided like this, but it is quite typical of what we find in our Montgomeryshire commons. This sheet again is part of your pack, and it is the land section. It describes the common as originally registered. So the entry number 1 tells you about what was registered in the first place, and it tells you that it was registered pursuant to an application number 398 made by the Ramblers Association in London. And as you can see underneath that, there are the words registration provisional. So the County Council received lots and lots of applications from owners of commons, from graziers, from the Ramblers Association, and from other members of the public to say this land is common land, or I have rights on common land, or I own common land. And for each and every one of those applications, we were required to make an entry, a provisional entry in the register. There was some degree of scrutiny. We were allowed to check that the land wasn't being registered as a common and as a town or village green, because if it was, then we had to check that. But largely, the entries were just put into the register and required to be put into the register as made. It was then advertised, but of course, in 1967 to 70, we didn't have the benefit of internet publishing. It was very much down to newspaper adverts, people becoming aware that the registers were on deposit and that they could go and have a look at them. And there was no individual notification of landowners, which does mean that we can appreciate that landowners might not have become aware that their land had been registered as common land. What you can see underneath that, entry number 2, that is that entry number 1 above was disputed. It became final, but actually some land was taken out, which is the hatched black area that you can see. And then down below that, you have a registration amendment, and then you've got part of it ceasing to become common land for another reason. So Register 2 tells us that the land was registered provisionally, but that was actually disputed. There was an objection. However, that objection and the modifications that resulted from it did not affect Area Y. What the law says is that if there was an objection to the initial registration, and that then went to the Commons Commissioner, who was external to the council, has a role quite similar really to PEDU now, that if that had already been considered by the Commons Commissioner, it had already been given due consideration. Therefore, there isn't the opportunity to reopen the case. However, where this was concerned, the dispute didn't go to the Commons Commissioner. It didn't have to. It was resolved by the Commons Registration Authority, I'll use a word missing there, through negotiation, as we were permitted to do. So in fact, where this is concerned, it hasn't had consideration by the Commons Commissioner because it didn't need to, and the dispute didn't actually result in any modification of Area Y. And as a result, registration of the remaining land, Area Y, and other parts of the common became final on 27th of July 1973, went into the legal register. So that part of the test is satisfied. We can continue considering the application. We also then need to consider, as officers, whether there were any rights of common on the land at provisional registration. And in the case of this one, there are no rights of common, grazing rights or other, which can include things like the right to take wood, the right to cut bracken for bedding. No such rights are recorded in the Register of Common Land as being exercisable over Area Y specifically. There are grazing rights recorded as being exercisable over other lettered areas of the common, because the graziers chose to put forward their registrations to say, I have rights to graze on MCL 76 and its Area A, Area B. And that's what they chose to do, although they didn't have to. The Graziers Association relating to the other areas of the common has been consulted about this application. In terms of the rights of common also, though, we have a statutory declaration from Mr. Wigley, who's known that he's lived in the area for a very, very long time. And he states that by his late father's account, Area Y has been exclusively grazed by the Rugriavel flock since the early 20th century. And just as a reminder, the Rugriavel flock is the flock owned by the applicant, Mr. and Mrs. Wilkins. So what Mr. Wigley is saying is the only people who put livestock on Area Y are the people who own the farm and Area Y itself, because common land can have different ownerships. So what we're saying here is there are no rights of common for other people to use the land. Where common land is concerned, largely it will have a single owner, but then it will have third-party registered rights for other people, nominated graziers attached usually to the land rather than a person, to put their animals on that land for pasture and with some associated rights, like the right to gather wood for the house. So in this case, what we have is an area of land that is owned currently by the Wilkins family, that there are no third parties who have rights to put their animals on it. So if that part of the test is considered, there are no grazing rights, it isn't doing what common land normally does. And that is quite important as well. Neither have the Graziers Association for the rest of the common put forward any comment or objection. So if they believed they had rights to use that part of the common, we could reasonably expect that they might have said something to us about that. We also need to determine whether the land is wasteland of the manor. So common land is manorial in origin, one of our oldest areas of law. The manorial land was divided into the domain land, which was for the sole and exclusive use of the lord of the manor, his house and immediate lands, the copyhold or tenanted land, and then there was the wasteland of the manor and the commons themselves. So the tenants who had the copyhold would have certain duties towards the lord of the manor, tasks they had to do, but they were also given allocated rights to use the common to put their animals on, usually in the summer when they had crops on the in-by land further down. So it was grazing in common, and it was specific to the tenants of the manor. Wasteland of the manor didn't normally have specific nominated tenants who could have so many animals on it, but it was part of the manor land. And this again is true common land, and we can't take it out of the register now if it's shown to have been wasteland of the manor. The definition of this is twofold. Clearly, it has to have been part of the manor at the time of provisional registration, or at some point before that, and also open, uncultivated and unoccupied at the time of provisional registration. So there are two parts to a test to satisfy there. And the council did pick up on that point because there is a lack of clarity about whether the land was open at the point of provisional registration, but other parts of the test were satisfied. So in terms of the evidence that we have around this, we have the tithe map and apportionment, determination of the tithe or tax due based on the value of land in the 1800s. And there is, in fact, just to note, there is a typing error where I've written Commons Commissioner in the paragraph around the tithe maps, which should be tithe commissioners. So again, they were external commissioners who were appointed to determine what tax was payable. The tithe commissioners were required to determine the proprietors and occupiers of each piece of land, and whether the said several lands are then cultivated as arable, meadow, pasture land, or as woodland, common land, or howsoever otherwise. So what they had to decide is what is the land, who occupies it, who owns it, and how is it being used? And that specifically did include being common land. So this is a screenshot extract that you have in your pack that the applicant has supplied from the tithe apportionment. And down in the right-hand corner, you can see you have area of land 1033. And interestingly, you've got some areas around that that are noted as mountain. But this is parcel 1033. And the tithe maps were, the tithes were made up of a tithe map showing the land and a tithe apportionment, which is a written description. So the written description for enclosures 1033 and also 1031 note that this area is shown as pasture land. It is owned by a Richard Hughes of the Cumcarnath estate in Llanbrynmawr, and it is tenanted by a William Beebe. So it is land that is of the manor, but it has a tenant. It is not considered part of the common itself. It is part of what was called copyhold. So this indicates that at that time, the 1840s, that the land was occupied by a single tenant and used as pasture, so not waste of the manor at the date of tithe commutation. So that's quite good evidence there. We have had commentary around from the objector around whether at a different point in time it might then have become waste of the manor. We did seek council advice around this application because it was initially presented to committee in 2018 but deferred because we had significant legal points made. It was a new type of application at the time and it was considered prudent to seek external council advice. And council's guidance around this is that no new manors were created actually after about 1290. So if the land wasn't waste of the manor in the 1840s, it's unlikely to have reverted to being that at some point after that. We also have a later tax survey, the Finance Act of 1910, incredibly detailed survey. Tax was never actually levied, but we do have very, very good records that have arisen from it. So the Finance Act of 1910, you have a duties on land values book, and you also have a map, and each plot of land is colour washed and described as a hereditament with a number, and the relevant hereditaments are 170 and 171. And again, the Finance Act, the commissioners were asked to note the use and state of occupation of the land at the time of survey. So again, they looked in detail, how was it being used at that point? And council pointed out that the Act did provide that the total value of the land should consist of the gross value of the land, from which was subtracted an allowance for any fixed charges and to any public rights of way or any public rights of way or user, and to any right of common and to any easements affecting the land. So what this is saying is that the owner of each area of land completed this tithe form, talked to the commissioners around it, and they were entitled to say, actually, there are people who have rights of common on my land, that devalues it, so can I have a reduction in tax, please? And the same with public rights of way. Now, they were not actually required to ask for a deduction, but there was a good chance that they were going to. And because it was actually an offence to falsify anything you put in this tax survey, if they had put information in around public rights of way or common land, it was good evidence of their existence. But they weren't required to claim it necessarily if they didn't want to. So you do have these this particular hereditament in your pack. I've only put the first and last pages on the slide because they are. So a number of points that were picked out and supported very much by council. There is an area of land here, there's an entry here in terms of how the land is held. Is it freehold, copyhold, or leasehold? At that point in time, in 1910, the manorial system of copyhold still existed. It was abolished later, in about 1926. But in 1910, it still existed. So, had the land still been of the manor with the tenant at that point in time, the expectation would have been that the entry would have said copyhold. It didn't, it says freehold. So again, we have evidence there around whether it was manorial at that point in time. And the second extract on the right is the one where you can ask where the landowner could seek deductions. And you will note that none is entered there for public rights of way, for common land rights. So council did point out that this point around not being noted as copyhold was important. And it was described as being a farm and outbuilding and wholly agricultural. There were no deductions for rights of common. And because these returns were made whilst copyhold still existed, it suggests the land was neither wasted land nor common land at the relevant time when the survey was done. Also, to add to this point, we have conveyances of land between 1922 and 1985 relating to the transfers between the applicant's family. And they do also span the date of provisional registration as common land, i.e. 4th of November 1969. Now, the fact that the land has been transferred between itself doesn't preclude it being waste land of the manor, because title in a manor can be transferred by conveyance in fee simple. Further information is needed, but we take the information in the round. But the 1922 conveyance, the earliest, includes a plan, and it distinguishes the farm and lands, which are in pink, from the sheep walk, which is in green, which is subject to rights of common, and which is also recorded as part of the common. So the application land is shown in pink in the same way as the enclosures surrounding Rugriavel House and the adjoining woodland. Most of the area coloured in green is now registered as being part of MCL 76. It forms areas C, Q and K of the common, And these rights of common are not disputed by the applicant. They are not trying to say that those areas shouldn't be recorded as common land. It is only Area Y that they're disputing. So this is a plan extracted and turned on its side to help with orientation. So it is to assist members in understanding where the application land is. I've put a blue arrow on top. And as you can see, that is coloured in pink in the same way as the fields immediately surrounding Ruby Owl House itself on the left. And then on the right, it looks quite grey in that particular scan. That is the green area, which is registered as common land and which is noted as Sheep Walk. The later ascents and conveyances, 1951, 1955 and 1985, they refer back to the schedule of the 1922 conveyance and they include the application land. So council's view on this was the demarcation between the common land, the Sheep Walk, and the land which is not common in principle supports the applicant's claim that the application land, in contrast to the Sheep Walk, is not common land or wasteland of the manor. So they have taken care in that their conveyance to distinguish between the two different types of land, that which is recognised by the applicant as common and that which isn't. The other part of the test around wasteland of the manor is whether the land was open, unoccupied and uncultivated. Now, in terms of whether the land was open at the time of provisional registration, this is an area where we don't really have sufficient evidence. As an officer, I conducted a site visit on the 28th of November 2018 to put up site notices around the application, but also to take some photographs. At that point, there was a partial boundary and embankment evident on the ground. It wouldn't prevent access though. It was easy to step over it. There was no fence or anything on top of it. The vegetation on the application land was similar to the rest of the common. And the OS base maps for things like the Finance Act 1910 and current OS base maps actually only show a partial boundary. The eastern boundary is incomplete, open to the rest of the common. So council advice was that we have insufficient evidence to conclude that the land was not open at the date of provisional registration. So there is an area here where we don't have enough information really. Here's a photo from the day when I went out, and as you can see, more or less in the centre of the picture, there is this kind of mound separating the two areas of land. And we have, similar vegetation on either side of that. So, on the ground, other than this mound, it's difficult to distinguish one piece from the other. So that concludes the evidence around whether it was wasteland of the manor or not. And that is quite a significant area which the objector has picked up on. Hence, so we're spending quite a lot of time looking at the evidence around that. The applicant also is required to demonstrate that the land immediately before it was registered was not a town or village green, in which case it should have gone on as a town or village green. And what they need to be able to demonstrate that the land was not land that had been allotted by or under any act for exercise or recreation of the inhabitants of any locality, that it was not land on which the inhabitants of any locality have a customary right to indulge in lawful sports and pastimes, and that it was not land on which the inhabitants of any locality have indulged in such sports and pastimes as of right for not less than 20 years. These were the original legal tests for registration of town or village greens under the Commons Registration Act of 1965. So in relation to that, recreational allotments were set out in enclosure awards. The enclosure awards being the process of converting communally used land to land in sole ownership and use. And it was the process, in fact, which began the movement of a lot of people from the countryside to the towns and cities in the Industrial Revolution, because land that was in communal use was taken out of communal use. So quite an extensive piece of legislation. What recreational enclosure awards did do was set out other types of land though. They did set out recreational allotments for the inhabitants to enjoy themselves. But in this case, there is no enclosure award identified that includes the application land. Enclosure awards that we do not have 100% coverage, and certainly not across Wales. Most of the Welsh Enclosure Acts were much later in history, because the area that was initially given priority for enclosure was the more productive, lower lying arable lands in particular. So as a result, we do find that the Welsh Enclosure Acts, there are a lot less of them. They don't generally include the uplands, and they're much later in history. And no enclosure award has been identified that actually relates to this area of land at all. No evidence has been put forward by the objector or any other person that the land was subject to any customary right to indulge in lawful sports and pastimes, or that the inhabitants indulged in such sports and pastimes in 20 years prior to the date of provisional registration. We do also, again, have a statutory declaration from Mr. Wigley, who's known the area for a very, very long time. And for as long as he can remember, the land subject of the application, Area Y, has formed part of Rue Griavel, the farm, and he's never regarded it as a village green. And he also goes on in his statement to explain what he understands a village green to be. So he shows a clear understanding of what it is that he's saying. And no counter evidence has been provided. Finally, we also need to consider whether the land is of a description specified in section 11 of the Enclosure Act of 1845. So with these Enclosure Acts, they did set out the types of land that could be enclosed and allotted to one person. And those classes of land include common land, whether rights are exercised over the land seasonally or not. So this land that we were talking about, that the lords of the manor allow their tenants to use, particularly in the summer, for grazing purposes. It includes stinted and regulated pastures. So a regulated pasture is owned by a number of different people and they graze it in common. A stinted pasture is slightly different. There is a total, limit, so a maximum limit on the number of animals that can be grazed, and each person who has a right to use it has a certain proportion, a stint or a couple of stints, which will equate to a number of livestock. Land with rights of vesture or herbage, and lot meadows. So these are really old types of pasturage, shared pasturage, which largely no longer exist. And enclosure did in fact allow a lot of those to be taken out of existence. Some areas of remaining regulated or stinted pasture were put forward for registration under the Commons Registration Act of 1965. So the Commons, the Enclosure Acts actually served to create some regulated pastures. Now, those didn't actually meet the definition for being registered. They shouldn't have gone into the register in the first place. But what the law says is actually there's no provision to take them back out now. So they shouldn't really have gone in the first place, but we can't take them back out now. So in terms of those legal tests, we've discussed at some length whether it is whether the land is common land. We've said that there were no grazing rights on it. And the evidence seems to indicate that it's not wasteland of the manor at the point of provisional registration. It was of the manor at one point, but it was tenanted. We've also got no evidence of any persons exercising the right to take any products from the land, i.e. vestige. So there's no third party saying, okay, this is your land, but I've got a right to take products from it. In a similar way to things like fishing and sporting rights, profit upon a third party can take the rights of a land that is owned by another. And also, Mr. Wigley, again, who's known the land a long time, denies that any other animals other than the Rue Griavel flock graze the land. And there's no herbage rights mentioned in the 1922 conveyance or the Finance Act returns. So again, when it comes to things like transfers of land, you could reasonably expect that any rights that third parties have, as they would be mentioned in there, as they do now with things like easements. There's nothing in there to suggest that there's any third party with a right. Now, enclosure award has been identified, including the area of land subject to the application, and that's the most likely means of designating an area as a regulated pasture. And Council actually advises that only 29 awards were made under the 1845 Act. After that, Parliament actually sought to preserve the open spaces and actually restricted the scope to enclose the land under the 1845 Act. So there's not that many awards anyway that would have this effect. We don't have evidence that a number of graziers have been making use of the land, not mentioned in the conveyances. The Finance Act returns indicate there was only one tenant on the land. To be a lot meadow, the land would have to be owned in fee simple by a number of individuals. It's clear from the conveyances that only one person owned the land. So it's quite interesting old forms of ownership. In this case, the evidence is that one person owned the land and one person was grazing it. We've also contacted DEFRA and Natural England because the land is in Wales. A lot of the original work around enclosure and the Enclosure Acts and common land was done by DEFRA and Natural England. So they are the relevant contact points still. And they haven't come back with any information to suggest that it's land of a description specified in section 11 of the Enclosure Act of 1845. And they do have information on their website around Enclosure Acts that may be relevant. So nothing has come back from them to suggest that it's one of these descriptions. In terms of the objection, this has been made by a representative of the Open Spaces Society, and the main focus of the objection is twofold. First, the burden of proof, proving the negative. So the applicant has raised, the objector has raised several points where he does not consider that the applicant has absolutely disproven. And this is something that we spoke with council about and sought an opinion on, because again, being a relatively new type of application, we need to understand what the burden of proof is. It is for the applicant to make their case, but to what extent can they exclude all other possibilities and prove the negative? And to what extent is it considered reasonable that they should have to do that? The Open Spaces Society also focused their objection on whether there is sufficient evidence to demonstrate that the land was not waste of the manor. In terms of the burden of proof, council's advice, having reviewed a number of different materials and cases, is that persuasive material suggests that the burden of proof is on the applicant, but that the standard is the civil standard, the balance of probabilities. They don't have to prove it beyond all reasonable doubt. It is the balance of probabilities. And to determine a matter on the balance of probabilities, a decision maker does not need to exclude all other possibilities, however remote they may be. However, rather, the decision maker must be satisfied, bearing in mind the evidence before it as a whole, that is more likely true than not, i.e. that it carries a reasonable degree of probability. So we cannot, as an authority, rely solely on the fact that there is no counter evidence. We do have to look in detail at the information that we have and try to reach the truth of the matter, but we are not required to exclude all other possibilities, however remote they may be. We take the evidence in the round as a body of information. In relation to whether the land was waste of the manor, it is felt that the applicant has demonstrated that the land was not part of a manor at the date of provisional registration, 4th of November 1969. That is supported by the Finance Act of 1910 documents, the series of conveyances between members of Mrs. Wilkins' family, and also the tithe evidence. There is less clarity about whether the land was open, unoccupied and uncultivated due to the incomplete eastern boundary. But to have been wasteland at the manor at the time of provisional registration, the land must have been both part of a manor and open, uncultivated and unoccupied. The applicant therefore only has to demonstrate that one of these is not met to fulfil this legal test around mistaken registration. Okay, so before moving on to the summary, I will raise one point which is not in your packs. We did, on advising the applicant and the objector last week that the matter would be coming to committee and giving them the link to the report, we did receive a late submission from the objector. The objector, however, though, has sent this in. It is outside any objection period. There is a statutory period of 42 days for advertising the objection, during which his initial objection came in. And the points raised, there was one typing error around the tithe commissioners, but the other points raised really related to the way in which the applicant felt that council had interpreted the evidence and their view on that. What it didn't do was bring to our attention any significant new evidence or case law. For that reason, on discussion with legal colleagues, we felt that it would not necessarily be proper to give you the information itself. We haven't given the applicant a chance to comment on it. But what we felt it was important to do was draw to your attention that we had a late submission, but that it didn't bring to our attention new case law or new evidence. I don't know, Colin, if you want to comment on that at all.
No, thank you, Sharon.
Chair, if you're happy, I'll give the summary and then the opportunity for questions, if that's helpful.
Yes, that's fine.
So based on the information put forward by the applicant, the documents already in the keeping of the Commons Registration Authority and council opinion, it is considered as officers that on the balance of probability, this application meets the criteria set out under paragraph 7 of Schedule 22 to the Commons Act of 2006. So I'll pose some questions if that's okay.
Yes, indeed. Before we go into questions, I did skip item number 6 on the agenda and item number 5, which I'll bring it in at the end. But item number 6 is declarations of interest on this application. So does anyone have any declarations of interest? No. Okay. We can go to questions. Any members got questions? Councillor Elwyn Vaughan, please.
Diolch, Cadeirydd. Well, thank you, Sian. Thank you for that very detailed and comprehensive report. I may say it's very interesting to say the least. It's a large area of ground. It's very, very high up. There's no community actually near it. Actually, the only house near it is Rhyw Gravel, which is interesting. I'll come back to that in a minute. Particularly pleasing for me is seeing the indigenous Welsh names, Cwm Ednant, Moelfre, Waintisa, Cwm Wernbach, etc. being used. If I may say in passing, perhaps a lesson to some in the Brecon Beacons area these days. But also I noticed the tithe maps, and yes, of course, Cwm Carnedd estate was a prominent estate in the area at that time, so that makes sense. And very interesting that William Bebb, who later went to America, was the tenant, more than likely the same William Bebb who became later governor of Ohio. Also, Mr. Weekly, the late Mr. Geraint Weekly, Rhosturnog, a neighbouring farm further down the valley, highly respected family, long-standing family, would know the area well, and therefore I'm very comfortable with his comments and observations there. In terms of the town and village green reference, anybody who knows this site will know, well, common sense prevails basically, that there's no way that it would ever been a town or village green. As I mentioned, there's no farms, no barring Rhyw Gravel, no hamlets or nothing in that area, but open mountain land. So therefore it would not be near or used, I can't see, by any town or village. And therefore, on balance, as you rightly say, Sian, I am content with the proposal as recommended here, and when the time is appropriate, Chair, I'm ready to move to that effect. Diolch yn fawr.
Might not be able to hear me. Sorry. Thank you very much, Councillor Elwyn Vaughan. Councillor Angela Davis, please.
Yeah, thank you, Chair. So I wanted to thank Sian for that very detailed presentation. I found this the most fascinating thing we've had through planning. Absolutely loved reading all those documents and learning about the history of all of this. And I must admit, I couldn't sit an exam on it all. It's all those different dates and acts, etc., quite complex. So it's interesting then to read here in the beginning that the onus was on the applicants to bring all the evidence, etc., forward. So I think that they need to be applauded, because, my golly, did they not bring us some information. So I'm minded to agree with Councillor Elwyn. So whenever you're ready, Chair, thank you very much.
Thank you very much, Councillor Angela Davis. Councillor Edwin Roderick, please.
Diolch, Cadeirydd. Thank you once again, Sian. I would love to have known you so many years ago. Back not far of 50 years ago, we were involved on something very, very similar to this after the Commons Registration Act. And in those days, there wasn't the people around who totally understood it. This reminds me very much of, funny enough, our own common, which was a manorial common. And it was registered by the of the manor. But after they had done it, just in time, a local farmer could see that there were enclosures already in the hill, in the way of ditches surrounding and showing sizes in acres, from 5 to 50, 60 acres. And those were taken out just in time. So I can see, and I'm quite prepared to accept, this is what has happened here in some ways. And where those enclosures were was on ground which was not convenient to farm, basically, in those days. We didn't have four-wheel drive tractors and all that sort of thing, you know. But since then, those enclosures were put up for sale, and they were bought by the adjoining farms of the common. Again, just to enlarge a bit on the common, the only way you can have rights to graze if you have a hefted flock. Now, usually on a manorial common, there is no heft. It's usually on open land. So I don't think that comes into this, but I'm quite happy to carry this forward. It's been very complex and interesting listening to you actually. So diolch yn fawr.
Diolch, Councillor Edwin Roderick. Next, Councillor Gareth E. Jones, please.
Thank you, Chair. I would reiterate thanks to Sean for a very comprehensive presentation. My question goes back to right to the start of your presentation. You showed a slide, and I think you said that some area in, I think it was red, is open access land. If this is approved as Officer proposals, would area Y remain as open access land?
That would be a decision for Natural Resources to Wales to make, because open access land is not solely land that is, it's not just common land. It can be mountain, moor, heath or down in terms of vegetation character. But in fact, where the open access maps are concerned, they are on decadal 10-year review at the moment. I think there's probably one coming up fairly shortly. So we do find this, if we have a change to the Commons Register, for example, through deregistration and exchange, that actually it takes a while for the access maps to catch up anyway. So that would be very much a decision for Natural Resources Wales. But I would just ask members to be aware that the impact of the application cannot be a matter in determining it. It has to be down to the evidence as to whether it is common land or not.
Thank you.
Okay, brilliant. No one else? Oh, Councillor Edwin.
Can I come back in, Chair?
Yeah, surely.
Just a matter of interest, actually. Whatever decision is taken here today, would that have to go back? Because really, this was an act of Parliament, wasn't it?
No, it won't, because what has happened is the Welsh Government has brought in the provisions of the Commons Act of 2006. It's entitled the Commons Registration Authority, which is the capacity that the council is acting in this case, to determine this case. So no, it is a county council decision in this particular case. Certain types of application where we are looking to enter land into the Common Register now that should have been put in the 1960s. Those are, in fact, those go external to PEDU. But this particular type of application, no, the council is entitled, in fact, required by law to determine it.
It's interesting to know that, because I was involved in some meetings maybe 2 years ago, and it was quite worrying. In fact, there was a Welsh Government appointee within the Brecon Beacons National Park, or Bonnie Brechenia, as we know it now, who was making representations to Welsh Government take all the hill rights off farmers. So, you know, this is very important that, shall we say, you keep your finger on the pulse in this job. Thank you very much.
Thank you very much, Councillor Edwin. Councillor Peter James, please.
Thank you, Chair. And thank you again, Sean, for your presentation. I was just thinking, going back to the first map that you're showing, and I don't know if you can bring that back on screen, but I did notice that the top right-hand corner, the purple line does cross the line of the red. Yeah, so you've got a, I think you said there's the purple line, or is that right in the top right-hand corner? Is that cross over there?
So you can see my arrow on the screen now.
Yeah, if you bring it down
Yeah.
To where the red border is around there,
Yeah.
just about there, there's I thought that was the purple line that's crossing over.
What we've got here is we've got so this is the boundary of the land affected by the application, but it also does coincide with a stream.
Oh, right, so that's a stream there then, is it? Sorry. Thank you for that. Thanks for giving my time.
Okay. Councillor Hugh Williams, please.
Yes, just an observation, Chair. Again, I'd add to other members' comments about the tremendous detail that Sian has brought together here. And it's just that one of the last things that was said to us was that we have to have a reasonable degree of probability. And I think it's been demonstrated in this presentation that we do have a reasonable degree of probability. So I will support the officer's recommendation.
Thank you very much, Councillor Hugh. Okay, members, the recommendation is that the application 17-001 CA be granted and be made, and that 19.27 hectareacres of land be removed from the Register of Common Land, as shown on plan in Appendix A. Councillor Elwyn Vaughan, are you still happy to propose this application?
Yes, I am, dear.
And Councillor Angela Davis, are you happy to second this application?
Yes, Chair, I am.
Okay, thank you. Before we go to the vote, Councillor Edwin, did you want to come in?
Sorry, I couldn't get my.
Okay, it has been proposed and duly seconded to go along with our officer's recommendation, as I've just outlined. If you are minded to go along with officer's recommendation, the voting slip will appear momentarily. Thank you. There it is, members. It's in the chat. It's hyperlink as usual. Click on that, that should take you. Slip.
I'm having trouble.
Okay.
I'm having trouble getting into the chat, Chair, but I will support.
Okay. You're having difficulties, are you, Councillor Gareth? And you, Councillor Peter, okay.
Oh.
While that's going on, I'll just add my thanks as well. Sharon, thank you for that very comprehensive report. It was, I enjoyed reading through it, I really
There we
did.
go.
Thank you.
Oh, brilliant.
If we're having difficulty, I'm happy to take verbals off the three councillors. Vice Chair, Councillor Gareth.
Chair, as we have a pause now, can I ask Sharon, there's a great deal of officer time has been spent on this. What's the process for an applicant in relation to paying for this? What sort of money is he have to pay for this, or is it all part of the service the county offer? You've had council, a great deal of your time. How was that gone about?
That's a fair question. When the legislation was brought in for this type of application, the Welsh Government did in fact envision that county councils would need to recover the cost at their time. So for this type of application, we are entitled in fact to full cost recovery. So what we're asking applicants at the moment is an upfront fee of £1,000, which covers the most basic costs of getting the application advertised. For some more complex cases, then, you know, if more time is taken, then we are entitled in fact to recover additional costs as well on a time recording basis. For applications that are considered to be in the public interest, i.e. addition of land back into the register, we can't recover our costs, but the determination is done by PEDU. So we can recover full costs for those types of application, yes.
Okay,
Just need an authenticator, I'm sorry.
it's okay. We'll take a verbal from you, Councillor Edwin.
I'm
Before.
okay, pass it, yeah.
Okay, and Councillor Gareth, you happy to go verbal?
And support, yeah.
And Councillor Peter James, you're supporting the application. Yeah, so the three councillors who couldn't vote are supporting.
Chair, so everybody's voted and all the votes are in favour
Thank you very
of the
much.
officer recommendation.
Once again, thank you very much, Sean, for that. We'll move on now to the last item, which was the delegated list, which came in via email. Excuse me, came in via email. Are there any observations or Can I have a proposer and seconder to accept them? Please. Councillor Elwyn Vaughan, thank you very much. Vice Chair, Councillor Gareth D. Jones, thank you very much. Okay, Carol, could we have the dates? We've got two dates coming up. We have the date for the next actual planning meeting, but in between now and then, we've got our AGM. That will be determined at a later date. They'll come through via email, but could we have the date for the next planning meeting? I believe it's sometime in June.
Yeah, Chair, the next planning meeting is the 8th of June.
Thank you very much. And like I say, members, we'll have that date come through to us for our AGM, which will be online. Okay. This leaves me now to thank the councillors here today and online, the officers who presented today, and members of the public and members of the press. I close this meeting. Thank you very much. If you could hang on as well.